Aaron Edwards with the Legislative Analyst's Office. So the recommendations that were described by my colleague would free up about $60 million from the recidivism reduction funds that the legislature could reallocate to other priorities that it deems to be a higher priority. So there are a lot of different options the legislature has for spending these funds. There are two specific recommendations that we have. The first is we would recommend using a small portion of the funds to evaluate CDCR's current rehabilitative programs, as my colleague described. The second is we would recommend that the legislature allocate remaining funds to incentivize reduced prison admissions. Under this proposed option, the legislature could expand the program that was created by SB 678, which rewarded counties for reducing the number of offenders who fail on felony probation and then are incarcerated. Specifically, the legislature could reward counties for successfully preventing offenders on other forms of community supervision that were created by realignment, including the post-release community supervision program and mandatory supervision, to incentivize counties to reduce the number of those individuals who are sent to state prison. The funds from the Recidivism Reduction Fund could be used as a sort of seed grant to allow counties to invest in evidence-based programs to address criminogenic needs for these offenders. And then counties could then be rewarded with a portion of the state savings that result from any reduction in prison admissions to provide an ongoing funding source to support these crime reduction programs in the future. Based on some preliminary data on PRCS and mandatory supervision failure rates that we received from the Administrative Office of the Courts, we're estimating that this type of a program could result in an ongoing reduction to the state prison population of in the low thousands of inmates annually. We know, however, this data is preliminary. We're still working with AOC to ensure the reliability of the data. And we would also note that this estimate assumes that this program would have the same success rate as SB 678 and achieve similar reductions in admissions to prison. So as we testified before this committee in the previous hearings, in a previous hearing, we are concerned that the administration's proposal to comply with the three-judge panel population reduction order, while it would likely result in short-term compliance, may not be able to maintain long-term compliance, and also that it relies heavily on costly contract beds. So while we think that using the recidivism reduction funds in the way that we've proposed would get the state closer to achieving long-term compliance and reducing reliance on contract beds, these investments alone are unlikely to result in a prison population reduction of sufficient magnitude to ensure long-term compliance or to substantially reduce the number of contract bed needs needed to maintain compliance. In order to accomplish those goals, we think the legislature would need to take some additional steps. And so in our recently released brief that we distributed to the committee in the previous hearing, we provide a framework to help the legislature think about some of its options to further reduce the prison population. Now, I'll go ahead and give a summary of each one of those options. Before I do that, I do want to note that we're not presenting these as LAO recommendations per se. That is because at this point, we haven't provided specific implementation details and we don't have the data necessary to determine what the precise population impacts would be. So we would need some more time to develop that, and we're happy to kind of work with CDCR and with your staff to further develop those proposals, if that's the directive from the committee. At this time, we are presenting these as more of illustrative examples of general strategies that the legislature could take. So with that, let me begin by talking about the first option we provide, which is reclassifying certain crimes that are currently felonies and wobblers to misdemeanors. So wobblers are crimes that under current law can be charged as either a felony or as a misdemeanor. For example, most drug possession offenses are wobblers or felonies. The legislature could reduce the penalties for drug possession offenses to make such crimes mandatory misdemeanors. This is just one example. There are many other wobblers, mostly for nonviolent property crimes, that could be reduced to misdemeanors. For this particular example, we estimate that changing drug possession offenses to mandatory misdemeanors would result in a reduction in the state prison population of a couple thousand inmates on an annual basis. However, there is a trade-off with this option to the extent that these affected offenders spend less time in custody, which they likely would. Then they could be at liberty to commit crimes in the community that they couldn't otherwise commit if they were incarcerated. So the second option that we discuss in our brief is reducing sentences for certain crimes. The legislature could choose to reduce the base sentences for some crimes, or it could eliminate certain sentence enhancements. There are really sort of endless options here. The penal code is quite broad, and there are a lot of different areas where you could concentrate. We don't recommend a specific option. But just say generally the trade-offs here are that you would get a significant, potentially a very significant reduction in the prison population on an ongoing basis, but similar to reclassifying crimes as misdemeanors, you would potentially allow offenders back into the community earlier than they would otherwise be in the community and could then commit crimes. So the third option we discuss is increasing early release credits that inmates can earn. The legislature could increase the cap on the amount of credits that inmates are eligible to earn, or they could further expand the number of inmates who are eligible to earn those credits. For example, inmates currently earn what are called milestone credits for completing certain programs. The credits range from 1 to 6 weeks per milestone, and inmates can earn up to 6 weeks of credit over the course of 1 year. The legislature could increase the amount of milestone credits awarded per milestone, and or it could increase the cap on the credits that can be earned in 1 year. In addition to reducing the state prison population, another advantage of this option is that it would also potentially increase participation in these rehabilitation programs to the extent that the credits are tied to completing the programs. Similar to the options I've already discussed, another trade-off again is that inmates would be returned to the community sooner than they might otherwise be. In addition, there may be some implementation challenges as this would require CDCR to change the way it calculates its sentencing credits, which is currently a complicated process. And it would also take a couple of years for a change in the sentencing, in the amount of release credits that inmates can earn to have a meaningful impact on the population if it was done prospectively. The next option I'll discuss is expanding the alternative custody program to male inmates. As was discussed in this committee's previous hearing, the state currently operates an alternative custody program for women who meet certain criteria. This program could be expanded to male inmates who meet similar criteria, such as being in prison, not having a current violent or serious offense, and being assessed as a low or moderate risk to reoffend. We don't have an estimate at this point of the actual population impact of this, but we could work with the department to put some numbers attached to that proposal. Similar to the above options, again, the trade-offs here is that you potentially be releasing inmates to the community earlier than they would otherwise be returned. This could be mitigated to some extent, however, if the administration prioritizes placement of individuals who have the lowest assessed risk to reoffend, and if the department places the individuals into programs that have been demonstrated to reduce recidivism. There is a challenge, however, to implementing this type of a program. According to the department, the process for placing female offenders in the current program is time-consuming and difficult, and so there could be similar challenges to expanding it to male inmates. And then finally, the last option is that the legislature could choose to expand rehabilitation programs in prison and for parolees. This approach could both improve public safety and reduce the prison population. However, one downside to this option is it is very difficult to estimate the precise impact on the prison population, and it would probably take some time for the full impacts to be felt. In addition, the option would likely require some upfront investment of resources in order to make these programs effective. So I'll just conclude by emphasizing a couple of points on which we touched in the last hearing. The first is that none of these options are perfect solutions. All of them have positive and negative trade-offs. I think the trick for the legislature will be finding options that conform with the legislature's priorities and minimize the negative trade-offs. And then the second thing is that many of these policy options would take quite some time to reach their full impact, a matter of years. And so the earlier the legislature chooses to act on these, the more likely it is to avoid having to continue funding costly contract beds or using early release or other ways to comply with the 3-judge panel order. So with that, I'll conclude my remarks. Happy to take any questions you have.
Thank you. I think maybe we will ask the Department of Finance and/or CDCR to comment on the suggestions.
Thank you. Audrey Bezos, Department of Finance. Fortunately, I was provided the opportunity to respond to a number of the LAO's recommendations at the last hearing, so I won't repeat myself there. On the long-term recommendations that the LAO suggested, while we are very fortunate to be granted the 2-year reprieve on meeting the 137.5 population cap, 2 years is not really that long in the grand scheme of things. So we believe it's of utmost importance to focus on measures and options as we outlined in the governor's budget that would guarantee compliance by February of 2016. And that is definitely the administration's priority at this point. However, we are open and willing and look forward to discussing long-term options. We agree that is something that needs to be discussed and looked into further.
Yeah, I think, since the administration's short-term proposals all seem to result in increasing the number of prison beds, it would be helpful if there was also an indication that you're thinking of a way out of spending, I think it's $500 million a year forever on increasing those beds. Do you have a phase-out plan? What are we doing here? I know that you're also asking for money to open a new prison in Stockton, which won't even be online till after the deadline for meeting the 3-judge panel population.
Definitely the plan we have before us relies heavily on capacity because we feel that is a guaranteed way to meet the population cap. However, I would note that there's also significant reductions from the increased credit earnings for second strikers. So that is something that does not require additional capacity. But we are working towards sort of looking at the long-term horizon and looking at population projections and interested in exploring and discussing ways to address the long term.
Okay. Working toward the long term, we do have several months, so I hope that we can look at some of that. Do you consider that we're on track to meet the June 30th population capacity?
Yes.
Okay, good. CDCR.
Thank you, Madam Chair. Scott Carney, Director of Administrative Services for the Department. In terms of the specific recommendations, I would echo the comments from the Department of Finance. Our immediate plan was focused on meeting the short-term benchmarks, but there are substantial investments proposed in rehabilitative programming aimed at changing the long-term trend, as well as specific proposals for medical, elderly, parole, and changing second strikers.
They're immediate?
We're moving forward on those proposals now to change the long-term trends.
Do you have a time frame? Because I was very interested in the fact that the three-judge panel did require an immediate increase in credits for nonviolent second strikers and allowing them to earn good credit times, at 33 1/3%, et cetera. So that's happened already?
So we've got the right program experts to give you the update. One of the key facts that I wanted to point out, because it also relates to our contracted facilities, is at the time of the January budget, we were demonstrating the commitment to implement rehabilitative programs broadly and offer that to all of our populations, as well as put in the resources necessary to move forward on what we suspected may be coming at the time of the court order. Mr. Oshina is here to provide the update.
Thank you. Madam Chair, members, I think I can provide some of the freshest information on the implementation of the three-judge panel stuff. So we're sitting at about 502 inmates starting from today to the first benchmark, which, as everybody has noted, largely gets met by the in-state capacity that we were able to lock up and to move populations there.
The instant capacity, excuse me, try to speak so that we can understand the sentence. Sometimes, people speak very fast and the sentences run together.
So let me slow down.
We're just policymakers. We don't live this.
Fair enough. We believe we'll make the first benchmark as well as the second benchmark, but it is heavily relying on the capacity things, that most of which have been cataloged already by the folks that have testified, and I think you know that and are aware of that from your prior hearing. Specifically on what I'll call non-capacity measures, some of which are in the governor's proposal, but some of which are also via the three-judge panel's order, are things that we are implementing now. And probably the simplest way to describe it is there are things that have clearly already been done, which are the capacity pieces, and then there are things that we are doing and things that are in development stage. And in those last two pieces is one of the things that you just referenced, Madam Chair, which is the credit earning scheme. So the effective date for credit earning is February 10th, which we peg as a start date to apply these credits to this population, because that is essentially the date of the order, and it was a logical place to then begin the application of it. So our teams now are identifying all of the folks that are subject to this credit earning. We are doing it in a manual-based process now, and providing notifications to the field are being prepared, as well as the inmate population that would be eligible. So that work has begun in earnest already. We hope to shift it toward our strategic offender management system, which is the database system that will make these calculations in the long run, because, of course, this is a practice that we hope should continue and will continue for quite some time. There is also then the development and expansion of medical parole, as well as elderly parole, and also the creation of what we call an enhanced alternative custody program for females. And then there is a lot of development work underway with respect to reentry centers, focusing most acutely now on female population, given the crowding issues that we have there that we've all come to focus on. And in fact, you will see some of this, I believe, when you tour tomorrow at CCWF. I was there myself a couple of weeks ago, and I do have a concern there, reported that to the Secretary, and so we were trying to develop options, and I think we'll talk about that more later perhaps in this hearing. But that is at least the freshest update that I think I can provide the members of where we are, both in terms of the capacity, but there's a fair amount of non-capacity activity that is occurring.
Okay. What I'm interested in is, do you have an estimate of the minimum custody inmates and the nonviolent second strikers? How many will be eligible for release once you get your calculations done?
Yeah, so some of the early estimates that I think we provided, I think I'm going to defer. No, I'm not going to defer. So by the June benchmark, because we had tried to take the numbers and place them up against the benchmarks as they were occurring, one being June 30th this year, and then the two Februaries. And for the categories of medical and elderly parole, I think the numbers were anywhere between 50 to 100 when the programs fully became mature. For the category, which is the biggest category, which is the credit earning, for the nonviolent second strikers, the estimates were, and I have to put my glasses on to read this. Yeah, we're 200 by the first benchmark, 700 by the second benchmark, and as much as 1,400 by the third benchmark, which is February 2016.
Okay. So
again, those were estimates, assumptions we were making, which just might revise when we get the actual
so
impact.
That by the time we pass the budget, we should know if that estimate of 200 is is realistic.
I think we'll have a pretty good feel for it.
Okay. And then the three-judge panel also required a new parole determination process to allow nonviolent second strikers to be eligible for parole once they've completed half their sentence. So how's that coming?
So I would put that in the category of the stages of development. The teams have got together. The Board of Parole Hearings has been spearheading that particular process, the eligible inmate population then being identified, and then a lot of discussion about the application of 50% and what that means. There's some internal debate and discussions about how you would actually apply that, and then the actual touching of files. We are now reading files to see exactly the extent of this particular population. I think the members will remember or appreciate the reason we went into this direction was the concern over one of the categories of increase in our population was the nonviolent second striker population. It's a condition that we are facing, not sure necessarily of the cause. We all have some theories that haven't borne out yet, but this is our attempt to try and address that condition. When you talk about long-term solutions and sustainability that are not capacity, this is certainly one of those that are in that category.
Right. Do we have an estimate of how many people may be affected by this?
We are targeting, well, we have an eligible pool that we think, and again, I'm referencing, I have so many numbers in my head, but we started with about 7,500 people that we thought were potentially in this particular category. But we have not gone through now and screened out certain folks. In this process, we were exempting, of course, life without the possibility of parole in certain populations at the end of the day. So it's something that I think we're going to have to continue to develop. We're going to have to continue to report to the committee and other parties in terms of our progress.
Do you have a time frame?
We expected that the first results of this, I believe, are going to be next year in 2015. And so the scoring of any results and assumptions we were making, owing to the fact that we had to have time to actually develop a parole determination process, and what that would look like would be where you would actually see the results of people coming out through this process, maybe in the year 2015, February 2015, with some specificity.
That's too long.
This
is what the three-judge panel requires us to do so that we get the population down. And it's one of the reasons, as you know, there have been the accountability problems over the years for the institution. We're all gone in 2015, or lots of people are. How do we actually make sure that we implement a new parole determination process based on the judge's order?
So we have a requirement to report monthly to the court, and I don't know if the members know that, but that is a report that also could be made available to you all, which will document our progress toward that particular objective. I will offer you an explanation that is not an excuse, but I think it is very important for us to actually know and identify the types of people we're talking about so that we can decide what a parole determination process is. If these cases are not as complicated as some of us believe they are, a process might be as simple as an administrative review and determination of it. But if they're very complicated, then it's maybe a process that is more akin to what we realize and know as a formal parole hearing process, which I think is a very complicated and lengthy and can be expensive process. So I think it behooves us to take the time and diligence to figure this out. And so even though it may be sooner Senator, than February 2015. For the purposes of reporting to the three-judge court, we have been, I hope, understandably conservative in all of our estimates for fear that we would actually over-report, over-project, and then miss the targets along the way.
Does the problem come with the definition of nonviolent?
No, I don't think there's a definitional issue per se.
Do the complications come, for instance, if they're in solitary confinement and we don't want to release them directly to the street? Can you comment on?
I think the complication is that the application of charging is different out there, and so we actually want to see the files because now we have a fair amount of discretion. When we've now got the opportunity and ability to look at these, we might be able to see a fact pattern ourselves and render a different professional opinion about the seriousness or of the particular matter and assess some level of risk ourselves and make a determination on whether this person should be released from prison and onto parole.
Okay. What about the parole of inmates with indeterminate sentences who've already been granted parole by the board but have future parole dates? Are you looking at that?
That's
too?
a subject that is very esoteric and complicated. I would actually have to defer to the Board of Parole to give you some answers on that.
Do you have any idea what the numbers are?
I think at present count, we were about 50 to 55 in range that are in that category today.
Okay. And then what about the expanded parole for medically incapacitated inmates or people who are over 60 and have served 25 years?
Again, those are the two that I would describe in the category of doing and in development. The teams have been meeting with the Federal Receiver's Office to identify eligible populations that fit the new expanded criteria.
Okay. I know that after the legislature passed the law, it took a number of years to find even 25 eligible people. Do you think we'll be able to work more quickly now that there has been experience with the law that's been in effect for a while?
It should go a little bit quicker. I think the process is the same by and large, that's going to be a parole hearing process. So we didn't pick up any speed in terms of the mechanics of it, but it's a matter of refreshing maybe folks that have been previously determined unsuitable under the prior criteria because there's a broadening of that category. At the same time, in the number of years, whether that population is still with us is uncertain, but it should move a little bit quicker than I think the frame of reference that we all have about the first medical parole program.
Okay, so when do we think that we'll be able to really launch into doing
Again, I think
that?
we conservatively set results for the second benchmark, February 2015. Doesn't mean that, again, we won't be having things going before that.
Okay, thank you. I didn't know if you wanted to comment on anything else.
If I could, I just wanted to reiterate the points that I think the members are making, as well as the Department of Finance, that sure, we have geared toward the capacity pieces of this, but I don't want us as California to think that the 2-year extension really gives us an opportunity to breathe. I was with the probation chiefs yesterday, and I know you were, and part of the point that I wanted to make to everybody is that we have to start digging into this stuff now, because everybody is right to point out the notion of durability and sustainability. And the other things that we were talking about, that we just talked about, as well as other things that we're conversed before now in the end of this budget season, those are things that are going to take more time, including sentencing. We don't really get results until afterwards. So the more we can do now, the better off we're going to be. And so I appreciate the fact that the committee is really focusing on decisions now that have an impact years from now.
Thank you. I did actually want to rather urgently ask you what you're doing about the court's order to expanded alternative custody for female inmates. I'm very disturbed about the fact that we have unfilled slots, many, 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 in the very few existing alternative custody programs that we have.
So I know we wanted to talk about this later, so maybe I'm getting a little bit ahead of it, but we have on the brink within a couple of weeks, I believe we'll finish up a contract with a McFarland facility that is really being designed as a female reentry facility. that will house approximately 260 female inmates. Then we also have for enhanced ACP itself for female inmates a facility in San Diego that we are planning to retrofit that we think will actually be available as early as July and perhaps August of this year, and has the capacity to house 50 to 80 female inmates and would be the first phase of an enhanced alternative custody program. We're in conversations probably every other day with folks, taking offers, proposals from different communities. I believe Assemblymember Jones Sawyer has expressed some interest, and so we are hoping to get down into his community to see what is available there. And part of it is I think that we've kind of suggested in this budget, if there were $40 million or some amount of money for reentry or enhanced alternative custody programs out there, what would the level of interest be in the communities out there? And so this is why we have a little departure with the Legislative Analyst's Office in that we think some of the conditions have changed since 2007. We are now post-realignment. After realignment, there have been a lot of changes in the criminal justice system. And so we have been hearing that there is interest and appetite out there. San Francisco, we have just finished, I think, inking the deal with them on the first pilot reentry. Marin County, we are told, is coming around the corner behind them. But it's been tough, largely because we think maybe we still didn't get the model or criteria right. That's only a 60-day program. And if we change the criteria to 4 to 6 months or 9 months or whatever it is that we can agree upon is a good effort to launch a new pilot, we have a deep interest in doing that, and we hope that that will make some difference.
So have you finished the recalibration of how you would deem a female inmate eligible? That's been done so we could fill the slots in the existing programs?
Yes, so the bottom line for us is that there was an exclusion in ACP that did not permit us to place serious and violent females into those programs. And so via the court order, that section has been waived. Because what we had learned as we were applying it, we had trouble filling it, we did realignment, and so many of the folks that would qualify are no longer with us. And so we began to touch files, look at files, review inmates, meet inmates, and it was our professional judgment that we could, if we were given the ability to now change the criteria to include certain serious and violent women, again, using some discretion and judgment in looking at these offenders, that they would be suitable for placement in an alternative custody program.
Okay.
And that's why we sought that authority.
Yes. So, okay, that's good. I'm very encouraged by that. Have CDCR looked at some kind of state-county partnerships for counties that are interested?
Yes. In fact, that was part of me yesterday trying to implore the county probations as well as talking to everybody. There are some cities and some counties that have reached out that have expressed an interest in this. Again, we're trying to be very open about what a reentry model would look like. We have a proposed version or concept per se of what it is, but we're very open to any discussion that either any county, any private provider, any city, that any jurisdiction has an interest in. It's one of, again, after realignment, post-AB 109 world, the relationship between state and locals has changed dramatically, and we think that maybe now is the time to, again, talk about reentry as an alternative in California.
Okay, thank you. Any comments or questions from members of the committee?
Thank you very much. First of all, I'll be here past 15. I'll be here to 2022, so you don't have to worry. You won't be by yourself.
Fantastic.
Yeah. I'd like to back up a little bit, really to talk to you more about kind of the department's philosophy around the credits, not to the point where, how many can be released based on it, but just your philosophy. Based on, for example, LAO talked about the milestone credit, and it's my understanding the department made a decision a couple of years ago to exclude college courses from earning milestone credits. I see somebody shaking their head no. Is that not correct? So currently, college courses can help you earn milestone credits?